know what I clicked on. Oh, let me share this with you. From time to time, my practice has always been to share really the same substantive information with students in my online classes that I do in my face-to-face classes. Although it has been up until this semester, they're getting recordings of these class sessions now, but in the past, it's been in a little bit different format. So, from time to time, just like I get good questions from some of you in this class, occasionally I'll get a good question from a student in an online class on a discussion board. And so this is from the fall of 2014. Let me just share this with you. This is a student who asked the question, I'm a little confused about the warrant process. If according to the exclusionary rule, a warrant has to be specific, how can law enforcement happen upon a crime accidentally and still use the evidence at trial? Are the rights of that individual not violated? And I think she was responding specifically to the discussion of this case that I've just shared with you, Massachusetts versus Shepard, because I'd said in that discussion, that exact thing, that, about accidental, right? So I thought that was a pretty good question. I would have responded to her even if it wasn't a good question, but I decided to give her the most thoughtful response that I could because I thought it was a thoughtful question. So I said, well, keep in mind 2 points. Number one, there are a few areas of our law that are as murky, even for prosecutors and defense attorneys, as the rights of the accused, particularly the question of what the Fourth Amendment permits with respect to searches and seizures. You can get different answers to questions depending on who you ask. And secondly, I'm not a lawyer, and I don't pretend that I know the definitive answers to these questions, or her question in particular, but I did make my best attempt. Warrants are not required if the police observe a crime in progress. Everybody probably gets that, right? The police actually observe a crime in progress. They don't have to stop and go get a warrant, right? They're just going to make the arrest or attempt to make the arrest, right? Or in cases of hot pursuit. Also, the rules may differ when we are talking about arrest warrants as opposed to search warrants. I'm not sure if I'm answering the question very well. If not, perhaps she can be a bit more specific. And she was, right? So she follows that by saying that my husband, this is another student gets in on it before she responds. Another student who gets on it. Paula, the original student is Paula. Cynthia says, Paula, my husband, who is a criminal justice major, said that there's a plain view doctrine that officers go by. If law enforcement officers can see evidence of criminal activity prior to entering or in an initial search, then the officer has the right to enter without a search warrant. If an officer sees a weapon from a legal vantage point, he is allowed to proceed with a search. This is applicable to homes and vehicles. He looked it up in his book. No, actually that's a good point because, one of the things that we haven't really talked about yet is what spaces are subject to the warrant requirement. Well, we've been talking about it almost exclusively in terms of a person's home, but the home is not the only private place. There's not just a presumption of privacy at home. So, for example, if the police pull you over when you're in your car and they suspect that you have something in your trunk or the boot, as our German friends call it, right? Is that what they call it, the boot? Right? Can they just go, crank the boot open and have a search? Or do they have to go get a warrant? Well, I mean, obviously they can ask you, right? And if they say, hey, can we search your trunk? And you say yes, then they don't have to go get a warrant. But if you say, no, I don't think so, what do they have to do? Why do they have to get a warrant? Why can't they just bust it open and search it? Well, yes, because of the Fourth Amendment, but I'm trying to get you to be more specific. What is it about? Let's by contrast, let's say that they pull you over and in the process of coming up to your window, they notice that in the passenger seat you have illegal drugs. Okay? Do they have to go get a warrant in that circumstance? No, because as she says, it's in plain view. Right? See, the difference is, the question is there a presumption of privacy? Okay? If it's on the passenger seat in plain view for anybody who walks up to your window to see, there's no presumption of privacy. But if you put it in the trunk or the glove box and lock it away, there is every expectation that that's private. Okay? If you're in your home and you're doing something illegal, maybe indecent, let's say, and the neighbors call and complain, the police can come and observe, you have the curtains wide open, right? You're displaying for anyone who wants. There's no presumption of privacy there, right? Why can the police arrest someone for committing a lewd act in public, where they wouldn't be able to arrest them for committing the same act in the privacy of their bedroom? Because there's a presumption of privacy in the bedroom. There's not a presumption of privacy if they're doing it in public, all right? That's really the most basic thing that we said. So she's absolutely right, even though she got it from her husband who read it in a book, which is perfectly fine. Okay? But Paula really wasn't asking about that. So she says, I guess what troubles me is this ruling. And she's kind of quoting the information that I shared with you and I shared with that class. The Supreme Court also ruled the exclusionary rule does not apply to evidence that is obtained by honest mistake. For example, searching the wrong car or finding the evidence in the wrong apartment and searching the wrong apartment and finding evidence. I guess I should have asked, how can evidence accidentally be discovered, or how can evidence accidentally discovered be admissible in court, considering the specificity of the Fourth Amendment and the exclusionary rule? It seems to me if the Fourth Amendment states, and no warrant shall issue but upon probable cause supported by oath or affirmation, in particular describing the place to be searched and the person or things to be seized, then evidence accidentally found should be suppressed. What defines an honest mistake? That's what she really wanted to know. And so I responded to her. The answer to your last question is the presiding trial court judge must take into account the circumstances of the specific case and decide whether the police error was a willful violation or an honest mistake. That's the debate that some of the participants in the panel discussion were having near the end of the program. I'm certainly not defending the logic, but I think it goes something like this. The exclusionary rule was devised by the Supreme Court as really the only feasible means of preventing law enforcement from flaunting the requirements of the Fourth Amendment and willfully conducting warrantless or otherwise improper searches and seizures. If the evidence is accidentally found by the police as a result of the search of the property that doesn't even belong to the suspect they are investigating, the search could not qualify as a willful disregard of the Fourth Amendment. It would be more like the police just happening onto the commission of a crime in progress. Again, not a lawyer. Hope this clarifies. Well, she wasn't satisfied. Okay? The conversation continues. I guess more than a question, I was commenting on the accidental findings. I understand if a police officer happens upon a crime in progress. Let's say for the sake of argument, a bank robbery. It would absolutely go without saying that the police officer should act. However, what I was referring to was, let's say you're at home and there is a police raid of your home, but the warrant lists your neighbor and specifies, say, illegal guns or whatever. Instead, the police make a mistake and come to your house instead. Let's say you have in your home medical marijuana or whatever. How are they going to justify the lack of a warrant with a specific address and specific items to be found? I guess my point is that the person who happens to be searched because of a mistake has lost his right to the reasonable expectation of privacy, as the warrant issued does not include his address or the items accidentally found. She's being very thoughtful. Wouldn't you agree? It's kind of scary. Not that I would break the law, but tyranny is really ugly. And I'm concerned that this sort of thing could get out of hand. I know that there is not much a common citizen can do about that, but if I were the one to be invaded by the police by accident, I would be shouting my rights have been violated. That does not change the fact that I would still have to go through the whole legal process. If I am off base, my understanding of this concept, please let me know. Okay, so here's my response. I think. There we go. What I was inelegantly attempting to suggest is this. The court seems to be mainly focused on whether the police willfully violated the search warrant requirement of the Fourth Amendment, not on whether the person who was not named in the warrant had his or her privacy violated. Right? That seems to be the concern of the court. Certainly not disputing your concern. I believe it's a valid one. No one is a greater proponent of the right to privacy. Well, that is true. In general, I agree with the assessment of Justice Louis Brandeis that the right to be left alone, that is the most comprehensive of rights and the most to be valued by civilized men. However, all of these cases in the area of criminal due process, indeed, in the broader area of civil liberties rights, ultimately come down to a matter of line drawing. Hey, we've talked about that point in here. Because the U.S. Constitution and the Bill of Rights are not crystal clear on these matters, in specific cases and circumstances, the courts have to determine where the line should be drawn between protecting the rights of citizens on the one hand and permitting the government the authority necessary to assert the state's compelling interest, maintaining order on the other hand. For most people, just a tweaking of the facts of a case can lead them to conclude the line should be drawn in different places. Consider a variation of your hypothetical scenario. I've pasted your scenario below and just changed a few words that are highlighted. Right? Let's say you're at home and there's a police raid of your home, but the warrant lists your neighbor and specifies, say, illegal guns or whatever. Instead, the police make a mistake and come to your house. Instead, let's say you have in your home a dismembered human body or whatever. How are they going to justify the lack of a warrant with specific address and specific items to be found? I guess my point is that the person who has so all the rest of that, all I did was take out medical marijuana and put in dismembered human body, and I suspect for a lot of people, that's very different. Right? See what I mean about the question of line drawing? I promise you this ends. Let's see how. I wonder how many people who might have agreed with your medical marijuana scenario that this person's privacy rights have been violated would now draw the line differently and conclude that this person's privacy rights are, if not irrelevant, at least secondary to the needs of the police to prosecute a murderer. And then I suggested some things, since she had some concerns about privacy rights. I suggested some things that lawyers typically suggest. I'm not a lawyer, but I have a good friend who's a lawyer, and these are the kind of things that he typically suggests to people. If the police come to your door with a warrant, and these things are hard to do, by the way, I think. Some people might worry that they're inviting some use of force against them if they were to exercise these rights. But this is the kind of things that lawyers say. Step outside and close the door behind you. If you leave the door open, officers are likely to blow past you to execute the search. Ask to read the warrant. Don't be satisfied with the officer just waving it in front of your face. If at all possible, insist on holding it in your own hands. Examine the warrant carefully to determine its validity. You should specifically look at the address indicated on the warrant, the date of the warrant, and the judge's signature. If the address indicated on the warrant is not your address or has a different apartment number on it, tell the officers that the warrant is not valid because the address on the warrant is 1234 Main and your address is 1244 Main, or that your apartment number is 406 and the warrant indicates apartment 416, and that you do not consent to the search. It is very likely that the officers will still execute the search, but now it will be harder for the police to claim that the mistake was a harmless error, that they made an honest mistake. If you put them on notice that they are making a mistake, the lawyers say, then you at least have a basis to challenge the harmless error or honest mistake premise. Okay? Asserting your rights may anger the officer, so be prepared for the police to take a more hostile posture toward you if you do so. Once again, not a lawyer, So be sure to ask an attorney if you have any reason to believe that you might find yourself in such a situation. Okay. Anyway, I thought that was not only an interesting conversation, but I think um, developed a little bit further the ideas that I was trying to share with the class, that class, and now this class, that stem from all of these, or at least from the harmless error um, exception to the exclusionary rule.